the topic focuses on taxpayers' rights and the right to an effective protection at the global level. So this is a topic which, in the framework of this session, will be addressed from two different perspectives. This perspective is the perspective of the remedies that taxpayers have, and later on Victor van Kommer will address this also from the perspective of good tax governance. So we don't think that tax authorities and taxpayers have to be one against the other. We think about how to build up a constructive relationship. And that is also very important at the global level. Earlier today, there was a question which was asked about whether the OECD is thinking about what can be done in case the information which is included is either not correct or different from one country to the other. Well, in my view, what has been done until now is that they have simply said, keep it at the national level. So you will have your remedies at the national level. Philip Baker and I think that if we have global problems, and if global problems justify that tax authorities give global answers, then it's also important that we try to build up global legal remedies, which doesn't mean that you necessarily end up in an international tax court, but you have to give taxpayers the opportunity to address the problem at the global level. You cannot just say an honest taxpayer doesn't have to be afraid of anything. Mistakes happen, and different points of view on factual issues also happen, and different interpretations by different tax authorities in different legal systems are also normal. So we are just saying that it is important to establish a discussion on what taxpayers can do if there is an inconsistency in the position of two or more different tax authorities. For Philip Baker and me, it is not sufficient to say that there will be a remedy or that there will be a compensation for damages at the national level. Therefore, we have carried out an analysis in the light of practice from over 40 countries in the world to try and identify minimum standards and best practices, and we feel that there will be an increased legal uncertainty in connection with the implementation of the BEPS. Not because countries want to do things their own way, but because they have problems. So one country may have problems with one implementation. The European Union, you heard it today from Dennis Faber, the European Union is implementing BEPS and going beyond BEPS. So all this can create differences, and all this can create uncertainty. We don't want legal uncertainty. Please understand, we are changing entirely what's going on in the world of international taxation. In times of changes, we cannot avoid to have situations where problems arise, but we have to do something in order to avoid that BEPS becomes a problem for business at the cross-border level. So Philip Baker and I thought about identifying some of the issues and offering the output of this in the form of minimum standards and best practices. It means not forcing countries to be aligned. Each country has its own legal and procedural systems. However, if one country has managed to solve some problems, that can be a best practice and could be useful also to solve the problems that other countries have. I was listening before to Daniel Vladimirovich, and he said that this country has generated case law on thin capitalization. Well, these problems have occurred also in other countries. So the idea of having best practices at the time in which we are finding global answers can be particularly important. So Philip Baker and I have made an analysis structured in 12 points, and I would like to give you an overview of what we have done until now. So the first 2 points are related to the issuing of tax returns and assessments. So earlier today we heard already twice about the fact that tax authorities are not just moving to automatic exchange of information, but they are also moving to e-filing, electronic filing of tax returns, and I'm glad to hear that things are going well in this country in this respect. Now, it's important also that we understand that there can be inaccuracies. Let me again make this example. If we have one company with a permanent establishment in another country, some countries are moving to e-filing of tax returns also for business taxpayers. Now, as you know, permanent establishment is a branch of the company in another country, which may have some compliance obligations in that other country. So, the same fact can be recorded in 2 different ways, by the country of what we call the head office and the country of what we call the permanent establishment. Now, it is good to have e-filing of tax returns. This is good tax governance. But, in my view, it is also good that the taxpayer is given the opportunity to correct that. Some people say, well, you can do that with cooperative compliance. Philip Baker and I say, yes, you can do that with cooperative compliance. This expression in English indicates when business opens its books to tax authorities in real time, which means that it's willing to have tax authorities at its premises all the time. And we say, yes, it is good to do that, but it must be the outcome of a free decision. Free decision means that it should not be the only way to avoid an inconsistency. If you want to do something, you have to be free to choose whether or not you want to do it. If that is the only way to avoid the problem, then it's no longer a free choice. So, once more, we should also talk about how taxpayers can prevent or counter problems. Because if taxpayers have problems, that can be bad for the system. We have to be effective in control and collection of taxes. We have to avoid all possible forms of people not paying taxes, but the reaction must be proportionate. And there is a right to an effective legal remedy, and I think, this is quite an important point that we have put on the agenda as a best practice. Please understand, I am just giving you a focus, some flashes on different points, because I think it's important that we bring together theory and practice. Russia is just one country of the world, and if we are at the global time, Russia has to understand also what potential implications arise in cross-border situations. The reaction has to be effective, but at the same time, it should protect rights of taxpayers. At the same time, it's important that we have some balance. Another issue is confidentiality. And this morning we heard that this country is ready and willing to go for automatic exchange of information as of 2017. We call it the first group of countries. Now, I think it's important that we all support transparency throughout the world. So, even if I am talking about this in a critical way, I am a supporter of international tax transparency with tax authorities. Because if we do not have transparency, then that is a way that can harm business, because business can have some hidden structures, which has been the case for many years, and then that can be negative, can harm the effectiveness of competition on the market. So I am a believer in tax transparency. Now, what happens with automatic exchange of information is that you, Russia, have all your information about Russian taxpayers, and you make it available to another country. Now, I hope you don't mind if I am making this example. The country is not chosen by coincidence, but it's not chosen as being opposed to Russia. It's being chosen as being a country with which we potentially now have issues in the European Union on data protection. This country is situated between Canada and Mexico, and it's in a different continent. So, with this country right now, we have problems as to the effective data protection, because they waive the effectiveness of data protection at condition that on the 6th of October 2015, the Court of Justice of the European Union, in the Schrems case, which is indicated in the fourth last bullet point of this slide, that country has been showing no similar level of protection of confidentiality. And of course, I don't need to talk in this country about issues which have been arising with Snowden and other things. So, the point is, if we make all information concerning the taxpayer available to tax authorities of other countries, then how can we prevent lower level of protection from being targeted with an effective reaction? We can't. So, this is a big issue. So, the issue is that there should be minimum standards of protection of confidentiality, and that those countries which do not meet those minimum standards should not be allowed to have automatic exchange of information. Now, this is of course insane from the perspective of cooperation among tax authorities, because the whole world is going for automatic exchange of information. Between 2017 and 2018, there will be a shift towards automatic exchange of information. Please understand, in some countries, if that information is leaked, you can be kidnapped. There can be big issues. So there are countries in the world in which if there is a leakage, then you can be kidnapped. And that is something which we really want to try and avoid. So it's not just a problem of the same level of protection of confidentiality, but it's also a matter of protection against leakages. So this is quite important. If a country does not provide sufficient level of protection against leakages, that country should be carved out. Personally, Philip Baker and I think that there shouldn't be just, bilateral flows of information, like, let's say, Russia gives information to Vietnam and then gives it 100 other times to 100 other countries. Personally, we think that it is a good idea to have a kind of central core with a switch with countries that can use or not use that information depending on how well they're doing. Philip Baker and I, and you can look at the 6th bullet point, Philip Baker and I think that it's a really bad practice, that of naming and shaming. Now, what is naming and shaming? Naming and shaming is putting on the website the names of taxpayers who are, held or accused of not paying taxes. Now, what do we gain from this? We completely destroy the reputation. And then you can say, it's good, because the ones who do not pay taxes have to be destroyed in their reputation. Well, we think that this is disproportionate. We think that if a taxpayer has the right to plead before court to protect his rights, then naming and shaming, it's something which can cause some damages, which are, number one, not strictly indispensable, and number two, which you cannot compensate. And you will just have to pay damages, and in some cases, like in the aloe vera case, it has proved that the type of compensation that you get, even for big cases, is insufficient. In Basel, we were given an example with the aloe vera case and the compensation of $1,000 for a multi-million case. So I think it's important that we try to prevent problems from arising, and this is also in the case of the so-called professional privilege. In many countries, tax information is held by the lawyers and by the accountants. So it's normal in many countries in the world that you have the accountants and the lawyers handling the same information. Do you know what? For lawyers, it's of course normal, the professional privilege. It means all lawyers, all correspondence between the lawyer and his client are always covered by the professional privilege. However, the same doesn't apply throughout the world for the correspondence or what the accountant keeps, the books. So what? So the professional privilege between the lawyer and the client turns out into, a funny story. We don't care about what the lawyer says with its client. We anyway get that information from the books. So that is not protected by privilege. So we think that this is below a minimum standard. We have identified 4 pillars for tax audits. As you can see, we differentiate between normal audits and more intensive audits. Philip Baker and I think that in the case of more intensive audits of taxpayers who have not been showing compliant, or in the case where you have strong suspicions that something is wrong with a practice or a taxpayer, then we should differentiate. If taxpayers are normally compliant and what they do is not suspicious, then they should be treated, the word trust between tax authorities and taxpayers should also apply here. I hope you don't mind if I'm making a comparison with insurance policies. With insurance policies, let's say that Victor van Kommer and I, we are 2 car drivers, and that Victor is always very compliant, and I am making a lot of accidents. Now, of course, it's fair that Victor's insurance policy is cheaper than mine because there is a higher probability that I make an accident, but of course, that doesn't exclude that Victor makes an accident. However, when it comes to me, it's fair if tax authorities acting as insurance companies pay more attention to what I do. So this is to show you that if there is little or no risk in respect of some taxpayers or some tax practices, then we should really make sure that the 4 pillars are preserved. And those are the proportionality, the prohibition of double jeopardy, the right to be heard. I also heard it during a question in the morning. The right not to self-incriminate. So this means that those 4 pillars are important. Let me just make an example with one of them. So, if you have, in a given situation, if you have already defended yourself before a court, you cannot be asked to defend yourself twice in respect of the same situation. This actually happens in many countries because you have criminal sanctions in tax matters and administrative penalties in tax matters. This is something which, at the end of the day, the facts should be the same. If you have infringed the rules, you have infringed them once, why should you plead twice? So this is for us against, or I should say, below minimum standards. Of course, this is a report of 96 pages, so I can only give you some flashes, but it's just to show you that what we're talking about, even if we are in one country or a different country, these are issues which are important for us all. At the time that states decide to go for international tax cooperation, then we really have to make our efforts to see how the goals, how the innovations are implemented. And therefore, we say one tax audit per year for this type of taxpayers is at least fine. Now, we think that the right to be heard is something which should be not just saying that you may be heard, but also you can present your views and can provide factual information. I'll say something more about it in the framework of cross-border exchange of information. Now, more intensive audits. More intensive audits, we think that tax authorities have to have the opportunity of being more effective with those situations in which there is a higher suspicion that something is wrong. However, that should not deprive the taxpayer of the right to remain silent. There should be authorizations for inspections and interceptions. And I think you can find it also interesting to have a look at recent cases from the Court of Justice of the European Union on the case of telephone interception and email interceptions. There is a case decided on VAT, value-added tax, in December, I think it was 16th December 2015. It's a case called WebMind licenses. It's a Hungarian case, and it's the use of interceptions not authorized for the purpose for which they were used. And it's quite an interesting case because it shows that if there are interceptions and if there is a higher suspicion, there should be stronger powers, but at the same time, this shouldn't deprive the taxpayer of the right to plead in his favor. And seizure. Seizure, when you seize the assets, that is certainly something which has to be regulated. You cannot allow seizure for purposes which are not indicated by the law. So if you actually seize the computers because you think that the computers can be instruments used to keep doing what has been done, or because they contain information, there are more proportionate ways of achieving that. Now we come to the 6 out of the 9 points of my presentation, so don't worry, it will not last for too much longer. Every system should allow for a judicial review of auditing. Judicial review means that tax authorities issue their acts. Of course, they can have administrative reviews of their acts, but it should always be possible for the taxpayer to obtain protection before an independent court. This mechanism should not last too long, in the interest of both parties. If you have a too long procedure, then the taxpayer will have to wait forever to get justice. But at the same time, for tax authorities, if you have to wait for too long and the execution of the request by tax authorities is stopped during the procedure, then also tax authorities have to wait too long for the collection. In this framework, therefore, we find it important that there is some balancing and that taxpayers also have the possibility of being reimbursed for the cost borne in order to have somebody defending their views. In many countries, this is not possible. So tax authorities raise an issue, taxpayer goes before court, and if the taxpayer wins, then tax authorities may not be condemned to pay the expenses of the lawyer. We find that this mechanism is structurally unsuitable for preventing possible disputes which are unfounded. And also, we do not like that in some countries of the world, judgments are not published. So if the taxpayer is wrong, then everyone should know what problem we had and what the interpretation we had. But at the same time, if the taxpayer is right, this is a judgment which needs to be good for a possible judicial precedent. It's not that because it goes against tax authorities, you don't want to publish it. No, this is unacceptable, but there are countries Turkey, for instance, which doesn't publish all its judgments. Now with penalties, I have to try and be a little bit shorter because it's 4:04. Now, penalties, principle of proportionality. In the European Union, we don't like that a reaction goes beyond what is strictly needed to achieve its goal. In other countries of the world, such as in the US, they talk often about the deterrent function. If you don't have a deterrent function, penalties are not effective. We think that these belongs to the past. In an era of international tax transparency, tax authorities have and should have access to all information. So why keeping sanctions of 300%, 400%, just because you say, so nobody will violate the rules? Of course we have to lead to a culture of not violating the rules, but at the same time, we have to try and avoid doing things which are disproportionate. And here in this context also, we think that do you get anything if you achieve a tax-driven bankruptcy? No, you just get that business goes bankrupt so that wealth in your country is no longer produced because this business goes bankrupt. So the revenue doesn't get the money because the business goes bankrupt. The person is out of business, so he's deprived and he's confiscated of his property. So this is something that Philip Baker and I don't find appropriate. Cross-border tax procedure. This is really exchange of information. We think that we should talk about this from two different perspectives according to whether we have exchange of information upon request or automatic exchange of information. Now, when we talk about exchange of information upon request, we found that in a number of countries, including the Netherlands, there was a right to be informed or be notified before information was exchanged. This right has been removed. We spoke with some national reporters. We didn't speak with the Dutch national reporter in this case, but also with other national reporters which used to have a right to be notified, and then they said to us, well, if we hadn't removed the right to be notified, we would have never passed the so-called peer review. And then Philip Baker and I said, okay, but then who did the peer review for for exchange of information? Tax authorities. So tax authorities of other countries were peer reviewing tax authorities of one country, so it was tax authorities peer reviewing tax authorities. Of course it's good that you have tax authorities checking that out, but the point is, it's very convenient between two tax authorities to say, well, rights of taxpayers, this is something which can be done later. So we, as you can see, we put the word disturbing. It's a disturbing development. Now, the right to be notified should not turn into a waste of time. So there are ways in which we have found some, and they are quoted in the report, this can be done quickly, but it's not a waste of time, because it's a way to prevent problem from arising. Now, with automatic exchange of information, as I said, the big issue is confidentiality. So, tax authorities of a country which shows it cares about protection of confidentiality should just stand for taxpayers' rights and say, we don't share tax information with that country because we know that in that country there is no data protection, effective data protection, and there is leakage. So here, we even think that tax authorities of the country which cares about effective data protection should be the one to protect taxpayers' rights, because we don't see taxpayers against tax authorities. We want to contribute to building up a constructive dialogue. And this can also be done through legislation, practice, and at the level of the institutional framework. And this is my last point. Number one, it's important that all positions of tax authorities are made available, which is also a matter concerning rulings. Now you may say, come on, now we will be having automatic exchange of information on cross-border rulings, so this is not a problem. Well, but the point is also that one should really know, also in purely domestic situation, what can be done and what can't be done. And we should also have the possibility of somebody, interacting with tax authorities from inside. Sometimes, as you can see, the ombudsman, as we have indicated in the slide, and that is something which can also contribute. You don't just protect your rights before courts. You protect your rights also by preventing problems from arising and establishing a constructive dialogue. And this is what we think also for the future. We are about to set up, under the joint flagship of IBFD and IFA, an observatory on taxpayers' rights. This is not just a way to say, let's protect taxpayers' rights. This is a way to bring it on the global tax agenda with a constructive attitude. Спасибо за внимание.
Спасибо огромное. Очень интересный доклад и отдельное спасибо за пунктуальность. Уважаемые коллеги, есть ли устные вопросы? Да, пожалуйста, представляйтесь, пожалуйста, зажмите, пожалуйста, кнопочку правую один раз. Пожалуйста.
Константин Пермикин, МГИМО, кафедра административного и финансового права. First of all, I'll say in English. First of all, thank you very much for the fact that there are such people as you and Philip Baker who care about taxpayers. It's a very good thing, and I have more a comment rather than a question. You mentioned that this whole procedure of data exchange, it creates certain costs for taxpayers. Well, it doesn't create certain costs, it creates crazy costs. Because the decision to tax is taken in one country, but you have to prove that you are right by using the information from another country. You have to engage many lawyers from abroad, and lawyers and tax consultants and everything. And so there arises a question: who has to pay those costs if you are right? And you mentioned that your view is that this should be done at the domestic level. But I think that if the information is provided from abroad, then it's the tax authorities from abroad who should, and it's the government of the foreign government who should compensate the costs for this, because it's the tax authorities from abroad who provided the false information, on which the domestic tax authorities made certain conclusions and basically taxed you.
It's not a comment. You prompt me a reaction. It's a great comment. Anyway, do you mind if I reply?
Yes, please.
May I? There are many issues. Number one, there are some countries always providing information, so they are bearing an enormous cost. Don't think about Switzerland, because Switzerland is a country which can perhaps afford this. But in some cases you have developing countries which are asked to provide information. Who pays the cost of the developing country providing information? Let me make an example. If you have on the one hand Uruguay, let's say it's comparable to Switzerland, but it's not Switzerland. But Uruguay will never ask information. It will always give information. So Uruguay and the United States, it would be mainly one flow of information. So that's one issue, which is fairly complex. We have developed exchange of information upon request in a way that keeps thinking about flows of information between two countries which give and take, and this is what makes it hard for Switzerland. Then we have a second issue, and it's not just the cost. Can you imagine how the taxpayer can get information from tax authorities of another country? It's not just a cost. If a taxpayer is not a resident, then it has to try and get information from a country with which it has no connection. Remember, in many times you have withholding taxes at source. So the taxpayer doesn't have anything there. So it tries to get the information, but it has no chance. This is unfair. So not just cost, but it's also the chance, one would say, to get that information. Plus, now we come to the cost, which is getting closer to your final point, and then I stop my reply. As for the cost, again, I think it's important, you cannot forget that we have national courts. So we have to live in the future with national courts. It's unthinkable for the time being that everything goes to an international tax court. There are cases of arbitration, of course. It's a more complex issue because there is also an issue of implementation. But right now, the issue is, what do we do with the cost of this information? So I can't think that the state supplying information doesn't request anything. I am just saying that the way that Philip Baker and we would solve it, I'm sorry if I'm always quoting Philip Baker, but it's just because we are working together, so I don't want to claim merits which are not just my own ones. We think that the right way to do it is that if a state loses a case before a national court with a taxpayer, and the taxpayer gives evidence of the enormous cost that it had to bear, that cost must be compensated in full. So we don't like the idea that you say, okay, the taxpayer wins the case, that's enough, you don't have to pay the taxes. No, that's not enough. Because if you have to defend yourself and you are right, then if you are right, you have to be as you were before. Because maybe to get that information from God knows where in the world, you have to pay an enormous amount of money. So if you're right, and if you're wrong, you're wrong. And so you have also to pay for the extra inconveniences that you cause to tax authority. And then, of course, we have an issue at the international level as to the effectiveness of the system. Because maybe in one country, there are all judgments against the taxpayer. And in the European Union, we had this case with Hungary, and some cases which were quite controversial, and that is, courts of one country just going only in one direction. So in some cases, that was something which has caused some inconvenience. So I think, this is how you prompted me, the reaction. It's clearly a very good point that you've made, and, thank you.